Your kind always parks wherever you want, don't you? The words slice through the parking garage's afternoon quiet, like broken glass across concrete. Officer Tyler Briggs stands behind a black Honda Accord, his hand already resting on his service weapon, his body language screaming confrontation before any violation has even been established. The fluorescent lights overhead flicker against his badge, number 473, as he circles the vehicle like a predator who's already decided his prey is guilty. The woman sitting in the driver's seat doesn't move. Not yet. Through the windshield, Amara Winters watches him approach with the kind of stillness that comes from having seen this dance too many times before. Her hands remain visible on the steering wheel at 10 and 2, her monthly parking pass hanging from the rearview mirror, catching the light with each small sway. She's been parked here for exactly 3 minutes, in space B14, the same space she's used every Thursday for the past 8 months, when she has business at the federal building 2 blocks away. I said step out of the vehicle. Now. Briggs's voice carries that particular edge of someone who's never had his authority questioned and doesn't plan to start today. His partner, Officer Marcus Rend, younger and eager to prove himself, already has his citation book out, though no violation has been observed or stated. The security camera mounted on the concrete pillar records everything: the valid parking permit, the properly positioned vehicle between the yellow lines, the woman who hasn't moved except to breathe. Amara's fingers drum once against the steering wheel, not nervousness, but calculation. Through her rearview mirror, she counts. 2 officers, 3 patrol cars now blocking the garage exit, which seems excessive for a parking issue. The timer on the parking meter, visible from her spot, shows 43 minutes remaining. She'd paid for 2 hours through the mobile app at exactly 2:17 p.m., and the receipt sits in her phone's payment history, timestamp intact. Ma'am, I'm not going to ask again. Briggs moves to her driver's side door, and now his hand has unclipped the retention strap on his holster. You're trespassing on city property. The first lie. This is a public parking garage, open to anyone who pays the posted rate. The sign at the entrance states clearly, public parking, $3 per hour, maximum 4 hours, Florida Statute Section 3-16.19-4-5, prohibits unauthorized vehicles only. She'd photographed that sign when she entered, as she always does, a habit that started 3 years ago after a similar encounter in Miami, though that time she'd been a prosecutor, not what she is now. Officer, I have a valid parking permit displayed, and I've paid through the city's official app. Her voice carries no fear, no anger, just a measured tone that suggests someone documenting facts for a record. May I ask what violation you're alleging? The violation is you're not supposed to be here. Ren speaks up now, his voice cracking slightly with inexperience. 29 years old, according to his personnel file, which is public record. 14 months on the force. 3 complaints already, though all dismissed by internal affairs as unfounded. The garage security camera catches everything, how Briggs signals to Rend, who immediately speaks into his radio. Unit 2-3 requesting backup at city parking structure B. Uncooperative suspect refusing lawful commands. The words flow like a script they've rehearsed, though Amara hasn't refused anything. She's asked a question, which under Florida law, she has every right to do. The echo of boots on concrete announces more arrivals. Sergeant Dana Hutchfield emerges from the stairwell, her presence immediately shifting the dynamic. 45 years old, connected to 3 city council members through her husband's construction company, which coincidentally wins most city contracts. These are all matters of public record, available to anyone who knows where to look. What seems to be the problem here, officers? Hutchfield's question isn't really a question, it's theater. She's already decided what the problem is, the black woman in the car who hasn't immediately complied with whatever narrative they're constructing. Suspect refuses to exit her vehicle, Sergeant. Briggs reports this like fact, though the security footage will show Amara has simply asked what violation she's committed. She's been loitering in the garage, probably scoping out cars to break into. The second lie. She's been here 3 minutes and 17 seconds. The timestamp on the security feed confirms this. Her hands haven't left the steering wheel. Her seatbelt remains fastened. She hasn't even turned off her engine, which idles quietly while the air conditioning fights the Florida humidity seeping through the concrete structure. If this story makes your blood boil, hit that subscribe button, because what happens next will have you questioning everything you thought you knew about justice. I need you to step out of the vehicle, ma'am. Hutchfield's tone carries that false sweetness, like artificial sugar that leaves a bitter aftertaste. We can do this the easy way or the hard way. Your choice. Amara considers her options. She knows her rights, more than they realize. She knows that Terry v. Ohio requires reasonable suspicion of criminal activity for a stop. She knows that Florida Statute 901.1-51 requires probable cause for arrest. She knows that everything happening right now is being recorded by at least 3 cameras: the garage security system, the body cam on Briggs's chest that he thinks he's disabled, but which is still recording audio, and the dash cam in Patrol Unit 4-7 that has a clear angle through the garage entrance. "Officer, I'm going to comply with your request," she speaks clearly, ensuring the cameras catch every word. "But I want to state for the record that I've asked what violation I've committed and received no answer. I have a valid parking permit. I've paid for my time. I'm parked legally in a marked space." Her movements are deliberate, calculated. Phone placed in the center console where it's visible. Hands moving slowly. Every action telegraphed to avoid any claim of sudden movement. She's done this before, though usually from the other side of the legal system. The moment her feet touch the concrete, Rend is there with his handcuffs. "Turn around. Hands behind your back. Am I under arrest?" She asks the question every civilian should ask, but most don't know to. "And if so, what's the charge?" "You're being detained for investigation." Briggs uses the magic words that he thinks give him carte blanche, but detention requires reasonable suspicion, and parking legally isn't suspicious. The handcuffs click with a sound that echoes through the garage. Too tight, of course. They always are. The metal edges dig into her wrists in a way that will leave marks. Evidence for later. Evidence for Monday, though they don't know that yet. Detective Roy Vance arrives as if summoned by some silent alarm that triggers whenever a black person questions authority. 51 years old, under investigation by Internal Affairs for evidence tampering, though that file is sealed and he doesn't know anyone outside IA has seen it. He approaches Amara's vehicle with the kind of purposeful stride that suggests he's about to find something. "Well, well, well." His voice carries the satisfaction of someone about to play a winning card. "Looks like we've got an expired registration here." The third lie. Her registration is current through December 2025. The sticker on her license plate proves it. The DMV database confirms it. But Vance holds up a citation book like he's discovered gold, already writing numbers that don't match what's displayed on her plate. "That's impossible." Amara's voice remains steady, though inside she's cataloging every violation of procedure, every breach of protocol, every federal statute they're trampling. "I renewed my registration in January. You calling me a liar?" Vance steps closer, his breath carrying the sour tang of coffee and something stronger. It's 2:43 in the afternoon, and he's already been drinking. Another piece of evidence for Monday. Captain Leslie Norwood's arrival completes the cast. She pulls up in an unmarked car, her appearance suggesting this is more than a random parking stop. Norwood, 48, passed over for deputy chief 3 times, bitter about it in ways that manifest as particular cruelty toward anyone she perceives as different or difficult. "What's the situation here?" Norwood surveys the scene. 5 officers, 3 patrol cars, 1 black woman in handcuffs, and nods like this is exactly the right response to someone parking legally in a public garage. Trespassing, expired registration, refusal to comply with lawful orders. Hutchfield rattles off the charges like items on a grocery list. "And I'm detecting a strong odor of marijuana from her vehicle." The fourth lie. Amara doesn't smoke, has never smoked, and her car smells like the vanilla air freshener hanging next to her parking pass. But it's a lie that's almost impossible to disprove in the moment, a classic tactic that turns a traffic stop into a drug investigation. "I need to search your vehicle, ma'am." Vance is already moving toward her car without waiting for permission. "Based on the marijuana odor and your suspicious behavior." "I do not consent to any search." Amara states this clearly, knowing it won't matter. They'll search anyway, claim probable cause based on the fictitious odor, and find nothing because there's nothing to find except legal documents in a briefcase they won't understand the significance of until Monday. The search is theater, performed for an audience of security cameras they seem to have forgotten exist. Vance tears through her glove compartment, scattering insurance papers and maintenance records. Wren dumps her work bag onto the hood, pawing through legal pads covered in neat handwriting they don't bother to read. Briggs checks under seats with the enthusiasm of someone who's certain he'll find contraband that isn't there. "Look at this." Hutchfield holds up a manila folder from Amara's briefcase. "Federal building parking permit." She's probably planning something. The fifth lie, and the most ridiculous. The permit is for the federal courthouse, where she has legitimate business they'll discover too late. But in their narrative, everything becomes sinister. A black woman with federal building access must be a threat, not a professional with clearance higher than all of theirs combined. Like this video if you know this story needs to be heard. And trust me, you haven't heard anything yet. The afternoon sun slants through the garage's open sides, casting long shadows that seem to stretch the scene into something surreal. 5 officers surrounding one woman who hasn't raised her voice, hasn't resisted, hasn't done anything except exist in a space where they've decided she doesn't belong. The security cameras capture it all. Every lie, every violation, every moment that will be reviewed in a federal courtroom they don't know is coming. You're under arrest. Briggs announces this with the satisfaction of someone who thinks he's won. Trespassing, providing false information to a law enforcement officer, resisting arrest without violence, and suspicion of possession of marijuana. None of these charges will stick. The trespassing charge fails because she was legally parked. The false information charge is baseless because she provided her actual driver's license when asked. The resisting charge is contradicted by the video showing her complete compliance. The drug charge will evaporate when the field test they'll never actually perform comes back negative for substances that don't exist. But right now, in this moment, they have the power. Or they think they do. The ride to the booking facility takes 17 minutes. Amara sits in the back of Briggs's patrol car, her hands cuffed behind her back, watching the city pass by through windows that don't open. The radio chatter fills the silence, other officers congratulating Briggs on catching another one, as if arresting citizens is a sport where they keep score. You picked the wrong city to try your games in. Briggs glances at her through the rearview mirror. We don't tolerate troublemakers here. She doesn't respond. There's nothing to say that won't be twisted, no words that will penetrate the narrative they've constructed. Instead, she mentally reviews the federal statutes they've violated. Title 18, United States Code, Section 224(2), Deprivation of Rights under Color of Law. Title 42, Section 198(3), Civil Action for Deprivation of Rights. The 14th Amendment's guarantee of equal protection. The 4th Amendment's prohibition against unreasonable search and seizure. The booking facility smells like industrial disinfectant and despair. The fluorescent lights buzz with a frequency that seems designed to cause headaches. The intake officer, a tired-looking woman named Patricia, barely glances up as Briggs escorts Amara to the processing desk. Another parking dispute? Patricia's question carries the weight of someone who's seen this pattern too many times. Trespassing and drugs. Briggs says this loudly enough for everyone in the booking area to hear. Probably more charges coming once we run her prints. The fingerprinting machine beeps as it captures each finger, uploading them to a federal database that will flag something unexpected. Not a criminal record. Amara has never been arrested before today, but a different kind of flag, one that requires special clearance to even see, one that will trigger notifications in offices these officers don't know exist. Name? Patricia asks, fingers poised over her keyboard. Amara Winters. Date of birth? March 15, 1983. Current address? Amara provides her townhouse address, the one that's listed on her driver's license, the one that's registered to someone whose federal employment records are sealed at a level that requires congressional subpoena to access. The booking process continues with mechanical efficiency. Height, 5 feet 7 inches. Weight, 140 pounds. Identifying marks. A small scar on her left hand from a childhood accident. Emergency contact. She provides her brother's number in Atlanta, knowing he won't answer calls from Florida numbers, but will see the voicemail. Any medical conditions we should know about? Patricia asks this rotely, not expecting the answer to matter. I take medication for blood pressure. Amara states this clearly, knowing they'll likely deny her medication for at least 24 hours, a violation of the 8th Amendment's prohibition on cruel and unusual punishment, another charge to add to the federal case building with each passing minute. The holding cell is 8 by 10 feet of concrete and regret. A metal bench runs along one wall. A toilet without a seat occupies the corner, offering no privacy. The temperature hovers somewhere between uncomfortable and unbearable, kept that way deliberately to encourage quick bail payments. 3 other women occupy the cell. 2 are there for prostitution, though one insists she was just walking home from her waitressing job when officers decided her skirt was too short to be legal. The 3rd woman, elderly and confused, was arrested for feeding cats in a public park, a violation of a city ordinance that criminalizes compassion. First time? The younger prostitute, who introduces herself as Diamond, though her booking sheet says Jennifer, sizes up Amara with practiced eyes. Yes. What they get you for? You don't look like the usual. Parking while black, apparently. Diamond laughs, but it's bitter, not amused. That's a life sentence in this city, honey. Judge Reeves will probably give you time served if you plead guilty, pay the fine, and promise to stay out of their good old boy's way. Judge Reeves. Amara knows him, knows his conviction rate, knows his pattern of harsh sentences for minorities and suspended sentences for connected white defendants, knows that he's up for re-election next year and campaigns on being tough on crime, which translates to being tough on anyone who looks like her. But Judge Reeves won't be handling her case. He doesn't know that yet, but his Monday morning schedule is about to be dramatically rearranged. The hours crawl by with sadistic slowness. No phone call, despite the constitutional requirement. No water, despite the Florida law mandating access to drinking water for all detainees. No medication, despite her medical disclosure. Each violation is another federal charge, another piece of evidence for what's coming. At 6:23 p.m., a U.S. Marshal enters the holding area. He doesn't announce himself, doesn't flash credentials, just stands near the intake desk where he can observe without being obvious. The desk sergeant, a veteran named Williams, who's been on the force for 22 years, suddenly becomes very interested in paperwork he wasn't looking at before. "Winters!" A guard calls her name like it's an accusation. "Your lawyer's here." She hasn't called a lawyer, hasn't been allowed to call anyone. But someone knows she's here, someone with the authority to send a federal marshal to observe without intervening. Not yet. The lawyer is a public defender named Marcus Chen, no relation to the name stipulation, who looks like he hasn't slept in 3 days and is surviving on coffee and determination. His suit is wrinkled, his tie askew, but his eyes are sharp when they meet hers. "Ms. Winters, I'm your court-appointed attorney." He says this formally, for the cameras and recording devices. "I've reviewed your case. There is no case yet, just charges that haven't been formally filed, but Amara plays along. Thank you for coming." Chen opens his briefcase, pulls out a legal pad, and begins asking the standard questions. But his pen moves across the paper in patterns that don't match his words. He's writing something else, something the cameras can't see from their angle. 3 words. "They know, Monday." She nods slightly, understanding. The federal database flag has been triggered. The U.S. Attorney's Office has been notified. The machinery of federal justice has begun to turn, slowly but inevitably. The arraignment is set for tomorrow morning, 8 a.m. Chen speaks louder now, ensuring the guards hear. "Judge Reeves is scheduled to preside. I understand. The charges are serious, but I believe we have a strong defense based on procedural violations." This is understatement at a cosmic level. The procedural violations are so egregious that the Justice Department's Civil Rights Division will eventually use this case in training materials as an example of what not to do. Chen leaves after 20 minutes, taking with him notes that will be filed under seal in federal court before the night is over. The marshal remains for another hour, his presence causing a subtle but noticeable change in how the guards behave. They bring water. They lower their voices. They stop the casual cruelty that usually defines the overnight shift. At 9:14 p.m., Amara is moved to a different cell, this one solitary. "For your protection," the guard claims, though she's posed no threat and faced no danger. The real reason is that someone with significant authority has made a phone call, and the sheriff doesn't want a federal incident in his jail. The solitary cell is identical to the holding cell, except for the absence of other people. The bench is just as hard, the toilet just as exposed, the temperature just as calculated to cause discomfort without crossing into actionable abuse. But now she's alone with her thoughts, with the mental preparation for what's coming. She thinks about the pattern, the system that allows this to happen. 5 officers responded to a black woman legally parked in a public garage. They manufactured charges, lied on their reports, violated multiple constitutional rights, and laughed while doing it. This is not aberration. This is standard operating procedure. This is what happens every day to people who don't have federal badges in their briefcases, who don't have U.S. attorneys on speed dial, who don't have the power to turn the tables come Monday morning. The fluorescent light in her cell flickers with metronomic persistence, creating a strobe effect that would be disorienting if she let it. Instead, she focuses on the timeline. Thursday afternoon arrest, Friday morning arraignment, weekend processing, Monday morning administrative hearing for the officers, who don't know it's been scheduled, don't know their union rep has been contacted, don't know their careers are about to intersect with federal oversight in ways that will follow them forever. Share this story with someone who needs to hear it, because justice delayed doesn't always mean justice denied. At 11:47 p.m., dinner arrives, a bologna sandwich on white bread that's more preservatives than food, an apple that's been bruised into submission, and a carton of milk that expired 2 days ago. She eats methodically, knowing she needs strength for tomorrow, knowing that every denied meal, every rights violation, every moment of deliberate cruelty is being documented by people these officers don't know are watching. Midnight comes and goes. The jail settles into its nighttime rhythm of misery. Distant sobbing, occasional shouting, the constant clang of metal on metal as guards make their rounds. Amara sits on the hard bench, her back straight, her mind cataloging every statute violated, every procedure ignored, every constitutional protection trampled. In her briefcase, which now sits in an evidence locker, is her federal identification. Not FBI, not DEA, not any of the agencies that might give these officers pause. Something more powerful in its own way. A federal administrative law judge's credentials, with jurisdiction over civil rights violations by law enforcement. The same judge who was scheduled to hear a different case Monday morning, a case that's been postponed to make room for something more urgent. The officers don't know that their own department's administrative hearing has been fast-tracked. They don't know that the U.S. attorney has already assigned a prosecutor to review the criminal charges, not against Amara, but against them. They don't know that the security footage from the parking garage has already been subpoenaed and copied, that their body cam footage has been preserved despite their attempts to delete it, that their radio communications have been transcribed and analyzed. They think they've arrested just another black woman who was in the wrong place at the wrong time. They think she'll plead guilty to lesser charges, pay a fine, and disappear into the system's statistics. They think Monday will be just another day of testimonies they've rehearsed, lies they've coordinated, evidence they've manufactured. They're wrong. At 2:16 a.m., Amara finally allows herself to lie down on the narrow bench. Sleep won't come. The lights never go off, the noise never stops, the discomfort is too calculated, but rest is possible. She thinks about the other women in the holding cell, about Diamond and the elderly cat lady, about all the people who pass through this system without recourse, without authority, without the ability to turn the tables. This arrest isn't about her. It's about them. It's about the pattern that needs breaking, the system that needs exposing, the culture that needs changing. She could have revealed her identity in the parking garage, could have avoided all of this with a flash of federal credentials. But that would have only protected her, not the next black woman who parks in that garage, not the next person these officers decide doesn't belong. The sacrifice is calculated, the suffering is strategic, the documentation is deliberate. At 4:33 a.m., the guard change brings new faces, but the same attitudes. The morning shift arrives with fresh contempt and institutional coffee, ready for another day of processing human misery with bureaucratic efficiency. They don't know that federal investigators have already pulled their personnel files, their complaint histories, their patterns of arrests that show clear racial bias. Winters, you've got court in 3 hours. The new guard, Officer Daniels, announces this like it's an inconvenience to him personally. But better clean yourself up. Judge Reeves doesn't like it when defendants look unpresentable. There's no mirror, no comb, no way to clean up after a night in a concrete box. This too is deliberate, designed to make defendants appear guilty, unkempt, criminal. The psychology of injustice starts before you ever enter the courtroom. She splashes water on her face from the sink that runs only cold, brackish water that smells like sulfur and neglect. Her clothes are wrinkled from sleeping in them, her hair disheveled from the absence of basic grooming tools. But her eyes remain clear, focused, determined. At 6:45 a.m., she's handcuffed again, too tight, always too tight, and led to a holding area where defendants wait to be transported to court. 7 others join her, all black or brown, all arrested for crimes that seem to evaporate under scrutiny: loitering, trespassing, resisting without violence. The catalog of charges used to criminalize existence. The transport van smells like vomit and fear. The windows are blacked out, preventing anyone from seeing in or out. The ride to the courthouse takes 12 minutes, but feels like an hour, every bump in the road amplified by the metal bench welded to the floor. As they arrive at the courthouse, Amara spots 3 things the officers escorting them don't notice. First, there are more federal vehicles in the parking lot than usual. Subtle, unmarked, but distinctive to someone who knows what to look for. Second, the court security is being supplemented by U.S. Marshals, not just the regular bailiffs. Third, and most telling, there's a notification posted on the courthouse door that Monday's docket has been revised, though the officers won't check that until Sunday night. The holding cell beneath the courtroom is newer, cleaner, but still a cage. She waits with the others as they're called one by one for their arraignments. Drug possession, guilty plea, time served, probation. Prostitution, guilty plea, fine, community service. The system churns through human lives with assembly line efficiency, each plea another statistic, another conviction, another win for prosecutors who measure success in guilty pleas rather than justice. Winters, the bailiff calls her name at 7:58 a.m., right on schedule. She's led up narrow stairs into a courtroom that smells like old wood and older prejudices. The gallery is nearly empty. A few family members, a reporter who covers the crime beat, And in the back corner, someone in a suit who's trying very hard not to look like a federal investigator. Judge Reeves enters with the pomp of someone who enjoys his power too much. 63 years old, white hair styled like a televangelist, eyes that have never seen a defendant they didn't assume was guilty. He settles into his chair like a king on his throne, ready to dispense his version of justice. State versus Amara Winters. The clerk reads the case number like it matters, like this is legitimate rather than theater. Charges include trespassing on city property, providing false information to law enforcement, resisting arrest without violence, and possession of marijuana. How does the defendant plead? Judge Reeves doesn't look at her, already shuffling papers for the next case, assuming this will be another quick guilty plea. Marcus Chen stands beside her, his presence a reminder that someone is watching, documenting, preparing. Your Honor, my client pleads not guilty to all charges and requests release on her own recognizance. This gets Reeves's attention. Not guilty pleas slow down his docket, complicate his statistics, require actual trials. He looks at Amara for the first time, his eyes narrowing as he takes in her composure, her direct gaze, her failure to appear properly cowed. The state requests bail be set at $5,000, Your Honor. The prosecutor, a young assistant state attorney named Bradley, who looks like he just passed the bar last week, reads from a script he doesn't understand the implications of. The defendant was uncooperative with officers and poses a flight risk. Your Honor, Chen interjects, his voice carrying more authority than his wrinkled suit would suggest. My client has no prior arrests, has established ties to the community, and was arrested for parking legally in a public garage. The charges are baseless, and we have video evidence proving, save it for trial, counselor. Reeves cuts him off with practiced dismissiveness. Bail is set at $2,500. Trial date set for... He consults his calendar, not knowing that by Monday his calendar will be irrelevant to this case. October 15th, next case. The gavel falls with finality that isn't as final as Reeves believes. Amara is led back to holding to await bail processing, knowing that someone, she doesn't need to know who, has already arranged for the funds to be posted. The machine is in motion now, grinding slowly but inexorably toward Monday. By 10:30 a.m., she's released. Her car has been impounded, of course, requiring additional fees to retrieve. Her briefcase is returned with everything displaced, documents crumpled, but the federal identification still sealed in its hidden compartment, unnoticed by officers who thought they were thorough. Standing outside the jail in the Friday morning sun, Amara takes her first free breath in 18 hours. Her wrists bear the marks of too tight handcuffs. Her body aches from the concrete bench. Her rights have been violated in ways that will be cataloged in federal court, but she's exactly where she needs to be. Chen appears beside her, having waited to ensure her release was processed correctly. Monday's hearing has been scheduled. He says this quietly, aware that even outside the jail, surveillance is possible. 9 a.m. sharp, courtroom 7. Courtroom 7. The federal courtroom typically reserved for administrative hearings. The one with enhanced security, recording equipment that can't be tampered with, and a raised platform that makes the distinction between judge and defendant unmistakably clear. They'll be notified Sunday night, Chen continues, handing her a business card that has more than just his contact information encoded on it. Their union rep has already been contacted. They're required to appear. Required, not requested. Federal administrative hearings for law enforcement misconduct are not optional. Officers Briggs, Rend, Hutchfield, Detective Vance, and Captain Norwood will receive summons Saturday evening, ruining their weekends with the sudden realization that they're not the ones pressing charges anymore. They're the ones being charged. Do you need a ride? Chen asks, though they both know alternative transportation has been arranged. No, thank you. I'll manage. As Chen drives away, Amara stands on the sidewalk outside the jail, watching the normal flow of traffic, the people going about their Friday morning unaware of what happened in a parking garage yesterday afternoon, unaware of what will happen in a federal courtroom Monday morning. A Blacktown car pulls up, windows tinted to legal limits. The driver doesn't get out, doesn't need to. She knows who sent it. She slides into the back seat, finding a change of clothes, her medication, and a sealed envelope with documents she'll need to review before Monday. The drive to retrieve her car from impound takes her past the parking garage where this started. Space B14 sits empty, though her payment was good until 4:17 p.m. yesterday. The security camera still points at that spot, its red recording light a reminder that everything was captured, everything was documented, everything will be evidence. The impound lot operates with the cheerful corruption of a legitimate racket. $300 to release her car, $100 for the tow, $100 for storage, $100 for processing fees. She pays with a credit card, ensuring there's a paper trail, another receipt for the growing file of damages she's suffered. Her Honda Accord has been searched again, more thoroughly than at the garage. The seats have been removed and hastily reinstalled. The door panels have been pried open, leaving gaps where they don't quite fit back together. Her legal pads have been photographed, though the officers who did so didn't understand the significance of the notes about federal statutes, about constitutional violations, about the administrative procedures that govern law enforcement oversight. Driving home finally, Amara allows herself a moment to feel the weight of what's happened. 18 hours in custody, dignity stripped, rights violated, treatment that would qualify as cruel and unusual if challenged in federal court, which it will be. Not criminally, not yet, but administratively, where the burden of proof is different, where qualified immunity doesn't apply the same way, where patterns of behavior matter more than individual incidents. Her townhouse sits quiet in a suburban development where the lawns are maintained by HOA requirements, and the neighbors pretend not to notice when police cars drive slowly past houses where black families live. She pulls into her garage, her own garage, where she has every right to be, and sits for a moment in the silence. Monday morning, Officers Briggs, Rend, Hutchfield, Detective Vance, and Captain Norwood will walk into courtroom 7 expecting to testify in someone else's case. They'll be wearing their dress uniforms, their medals, their confidence that the system protects them. They'll have their union representative, their coordinated stories, their assumption that judges always side with law enforcement. Instead, they'll find themselves facing a federal administrative law judge who has personal first-hand experience with their conduct. A judge who cannot preside over the criminal cases that will likely follow. She'll have to recuse herself from those, but who has full authority to conduct administrative reviews of civil rights violations by law enforcement officers. The revelation won't come immediately. First, there will be confusion as they realize they're the subjects of the hearing, not witnesses. Then, there will be the slow dawning recognition as Amara Winters enters not through the defendant's door, but through the judge's chambers. Finally, there will be the moment when she takes the bench, when she reads their names into the record as subjects of federal investigation, when she begins the formal process of documenting their violations with the precise, methodical approach of someone who has experienced each violation personally. But that's Monday. Today is Friday, and Amara has work to do. She opens the sealed envelope from the car, finding transcripts of the officers' radio communications, their previous complaints, their patterns of arrests showing clear racial bias. The U.S. Attorney's Office has been building this case for months, waiting for the right moment, the right incident, the right evidence to establish a pattern of practice that violates federal law. Her arrest wasn't random. She was chosen for this, asked to put herself in harm's way to gather evidence that couldn't be obtained any other way. A federal judge experiencing firsthand what happens to black citizens in parking garages, in traffic stops, in the thousand small ways that constitutional rights evaporate when skin color becomes probable cause. She showers, washing off the jail smell that clings like an accusation. The hot water stings the handcuff marks on her wrists, evidence that will be photographed and submitted into record. Her medication sits on the bathroom counter, the doses she missed during illegal detention, another violation to document. By 2 p.m., she's at her home office, drafting the administrative findings that will be entered into federal record. Each violation meticulously cataloged, each statute cited with precision, each pattern of behavior linked to previous complaints that were dismissed by internal affairs, but remain relevant to federal oversight. The phone rings at 3:17 p.m. The caller ID shows a block number, but she knows who it is. Judge Winters? The voice belongs to the U.S. Attorney for the Middle District of Florida. I wanted to confirm you're prepared for Monday. I am. The officers have been notified they're under investigation? They will be by Sunday night. Their union has been contacted. And you're certain you want to proceed with the administrative hearing before filing criminal charges? Administrative proceedings have a lower burden of proof. We can establish the pattern, document the violations, and create a federal record that can't be sealed or expunged. The criminal charges can follow once the administrative record is established. There's a pause, the kind that comes when legal strategy meets personal experience. What you went through yesterday, I want you to know it wasn't taken lightly. We needed this evidence, but we recognize the sacrifice. Sacrifice. 18 hours in a concrete cage, handcuffs too tight, rights violated, dignity assaulted, all to prove what every black person in America already knows, that the system is broken, that the protections are theoretical, that justice depends more on who you are than what you've done. It was necessary. She says this simply, without emotion, because emotion has no place in what comes next. Monday isn't about revenge or even personal vindication. It's about creating a federal record that can't be ignored, establishing patterns that demand oversight, forcing changes that should have happened decades ago. The rest of Friday passes in preparation. She reviews case law, precedents, administrative procedures. She drafts questions for the officers that will reveal not just their actions Thursday, but their patterns over years. She prepares exhibits, the security footage, the dispatch logs, the booking records that show how a legal parking spot became an arrest for drugs that didn't exist. Saturday morning brings a knock at her door. A courier delivers a package requiring signature, the complete internal affairs files on all 5 officers, unsealed by federal court order. Reading through them is like watching a pattern emerge from static. Dozens of complaints, all with similar elements: black citizens, manufactured charges, excessive force, false reports, all dismissed by internal affairs as unfounded or not sustained. Officer Briggs, 14 complaints in 12 years, all but 1 from black citizens, all dismissed. Officer Rend, 3 complaints in 14 months, pattern of illegal searches, all dismissed. Sergeant Hutchfield, 22 complaints in 18 years, harassment, false arrest, civil rights violations, all dismissed. Detective Vance, 31 complaints in 23 years, evidence tampering, false reports, excessive force, all dismissed. Currently under federal investigation for unrelated corruption. Captain Norwood, 43 complaints in 24 years, discrimination, retaliation, covering up subordinate misconduct, all dismissed. The pattern is clear, documented, undeniable. And Monday, it becomes federal record. Saturday afternoon, she drives past the parking garage again. Space B14 is occupied now by a white SUV. No police presence, no officers claiming trespassing, no 5-unit response to a legally parked vehicle. The difference is obvious to anyone willing to see it. Her phone buzzes with a text from Chen. Officers received their summons. Union rep is scrambling. They're calling colleagues trying to understand what's happening. Let them scramble. Let them feel what every citizen feels when blue lights appear in their rearview mirror. Uncertainty, fear, the knowledge that power is about to be exercised by someone who sees you as guilty until proven otherwise. Saturday night, she reviews her notes one final time. The administrative hearing will follow strict procedure. Opening statements establishing jurisdiction and authority. Presentation of evidence, including her first-hand testimony about Thursday's events. Examination of patterns showing this wasn't an isolated incident. Findings of fact that will become part of federal record. Recommendations for remedial action that can include termination, decertification, and referral for criminal prosecution. The officers will have representation. They'll object, claim qualified immunity, argue that they were following department procedure. None of it will matter once the evidence is presented, once the pattern is established, once the federal record shows what happened in that parking garage was not an anomaly, but standard practice. Sunday morning arrives gray and humid. Typical Florida weather that can't decide if it wants to storm or just threaten. Amara attends her normal coffee shop, orders her usual medium roast with 1 sugar, sits at her regular table by the window. The barista, a young woman named Sarah, who's worked there for 2 years, doesn't know her customer is a federal judge, doesn't know what happened Thursday, doesn't know that tomorrow morning will shift the balance of power in ways that ripple through the entire department. The coffee shop's television plays local news on mute, a segment about rising crime rates featuring Captain Norwood claiming the department needs more resources, more authority, less oversight. By tomorrow afternoon, that same news channel will be reporting on federal oversight of the department, administrative findings of systematic civil rights violations, 5 officers facing federal investigation. Her phone rings at 2 p.m. Sunday, Sergeant Hutchfield's personal number, which she doesn't answer. The voicemail is predictable. Confusion, anger, threats about lawsuits for false allegations. Hutchfield doesn't know yet that the allegations aren't false, that the evidence is overwhelming, that the hearing tomorrow isn't a trial where reasonable doubt matters, but an administrative proceeding where patterns and probabilities rule. Sunday evening, as she prepares her judicial robes, the ones that were in her briefcase Thursday, sealed in a compartment the officers never found, she thinks about Diamond in the holding cell, about the elderly cat lady, about all the people who've been processed through a system that criminalizes poverty, race, existence itself. Tomorrow won't fix everything. 1 hearing, 5 officers, a single department. It's a drop in an ocean of institutional bias, but drops accumulate. Precedents build. Federal oversight expands. Change happens not in dramatic moments, but in methodical documentation of patterns everyone knows exist, but few can prove. The sun sets behind her townhouse, painting the sky in shades of pink and orange that would be beautiful if they weren't filtered through the memory of 18 hours in a concrete cage. She hangs her robes carefully, ensuring they're perfectly pressed for tomorrow. The federal seal on the pocket catches the last light of day, an eagle holding scales of justice that tomorrow, finally, might actually balance. Her alarm is set for 6 a.m., though she knows she won't sleep much. Too much anticipation, too much preparation, too much writing on what happens in courtroom 7 tomorrow morning. The officers are probably strategizing right now, coordinating their stories, believing they can explain away Thursday's events as a misunderstanding, an overreaction, a justified response to a suspicious person who happened to be black in a parking garage. They don't know about the security footage from multiple angles. They don't know their body cams were still recording when they thought they were off. They don't know their radio communications were transcribed in real time. They don't know that every lie they've told has been documented, every violation cataloged, every pattern analyzed by federal investigators who've been waiting for exactly this kind of evidence. The clock on her wall ticks toward midnight, toward Monday, toward the moment when Amara Winters stops being a victim of false arrest and becomes the federal judge who experienced firsthand what she's been appointed to investigate. The transformation won't be dramatic. No revealing of hidden badges, no dramatic proclamations, just the quiet authority of walking through the judge's entrance instead of the defendant's. But first, she needs to sleep, or at least rest. Tomorrow requires clarity, precision, the kind of cold legal focus that cuts through excuses and exposes truth. Tomorrow, Officers Briggs, Rend, Hutchfield, Detective Vance, and Captain Norwood learn that the black woman they laughed at while arresting, the one they charged with crimes that didn't exist, the one they processed through their system like countless others, has the power to process them through a different system. One where their badges don't grant immunity, where their lies don't become truth, where their violations have consequences. The last thing she does before attempting sleep is check the federal court docket online. There it is, published for public view. Administrative Review Hearing, RE, Officers Briggs, Rend, Hutchfield, Vance, and Captain Norwood. Presiding, Administrative Law, Judge A. Winters. Monday 9 to 1 a.m., Courtroom 7. The officers have probably seen it by now, have probably Googled her name, found her federal profile, realized with growing dread what Thursday's arrest actually means, have probably called their union rep again, their personal lawyers, anyone who might explain how to escape what's coming. But there is no escape from federal documentation. No internal affairs to dismiss complaints as unfounded. No qualified immunity for patterns of constitutional violations. No thin blue line that extends into federal courtrooms where the evidence speaks louder than badges. Monday morning is 8 hours away. 8 hours until she walks into courtroom 7. 8 hours until the revelation that transforms everything. 8 hours until the system that processed her begins to be processed itself. The handcuff marks on her wrists have faded to faint bruises, but they're still visible. Evidence of Thursday's violations, reminders of why Monday matters. She touches them gently, thinking of all the wrists that have borne similar marks, all the people who didn't have federal authority to fight back, all the voices silenced by plea deals and poverty and exhaustion. Tomorrow she speaks for them too. Not with anger or emotion or personal vendetta, but with the precise application of federal law to patterns of behavior that violate everything law enforcement claims to represent. Tomorrow the laughter stops, and the reckoning begins. The federal courthouse stands like a fortress of marble and justice at 9 a.m. Monday morning, its columns catching the early light in a way that makes them seem to glow with purpose. Amara Winters enters through the employee entrance, her federal identification scanning smoothly through security systems that recognize her as someone who belongs here. Not as a defendant, not as a victim, but as an arbiter of justice itself. The hallway to courtroom 7 echoes with her measured footsteps. She carries her briefcase, the same one the officers pawed through Thursday, looking for drugs that didn't exist while missing the federal credentials hidden in its sealed compartment. Today, those credentials won't be hidden. Today, they'll be displayed on the bench where 5 officers are about to learn that their actions have consequences they never imagined. In the secured preparation room adjacent to the courtroom, she changes into her judicial robes. The black fabric falls with practiced precision, the federal seal embroidered on the pocket catching the fluorescent light. She pins her hair back in the same style she wore Thursday, the same style that Sergeant Hutchfield mocked as trying to look professional while fastening handcuffs too tight to be anything but punitive. Through the door, she can hear voices in the courtroom, nervous, confused, angry. The officers have arrived with their union representative, a man named Gerald Foster, who's defended dirty cops for 20 years and thought this would be another easy case of backing the blue. He's about to learn differently. "This is harassment," Captain Norwood's voice carries through the oak door. "We were doing our jobs. That woman was suspicious, and we had every right to investigate. The charges will stick," Detective Vance adds, with confidence born from years of having his lies believed. We've got 5 officers whose testimony aligns perfectly. Of course it aligns. They spent the weekend coordinating their stories, not knowing that their coordination itself was being monitored, their phone calls logged, their text messages subpoenaed by federal warrant issued Saturday morning. The bailiff, a U.S. Marshal named Thompson who served federal court for 15 years, knocks twice on her door, the signal that it's time. Amara takes one breath, centers herself in the law rather than the personal, and nods. All rise! Thompson's voice fills the courtroom with authority that makes everyone stand reflexively. The United States District Court for the Middle District of Florida, Administrative Division, is now in session. The Honorable Judge Amara Winters presiding. She enters through the judge's door, climbing the 3 steps to the bench with deliberate precision. The courtroom falls silent, not the respectful quiet of normal proceedings, but the shocked stillness of recognition hitting like cold water. She can see it in their faces, the exact moment when each officer realizes who she is. Briggs goes pale, his jaw dropping open in an expression that would be comedic if it weren't so satisfying. Wren stumbles backward, actually taking a step away from the defendant's table like distance might somehow change reality. Hutchfield's face cycles through confusion, recognition, and rage in the span of 3 seconds. Vance's hands clench into fists, his tell when he's caught in a lie. And Norwood, Captain Leslie Norwood, who dismissed complaints for years, who protected bad cops and punished good ones, who built her career on a foundation of protected prejudice, simply stares, her worldview crashing down around her in real time. Please be seated, Amara says, her voice calm, professional, carrying no hint of the 18 hours she spent in their jail. The gavel sounds once, sharp and final. Gerald Foster is on his feet immediately. Your Honor, I must object. There's clearly a conflict of interest here. You cannot preside over a case where you're the alleged victim. Mr. Foster, she responds with the patience of someone who anticipated this objection, you're correct that I cannot preside over any criminal proceedings that may arise from Thursday's incident. I've already recused myself from those under 28 U.S.C. Section 455. However, this is an administrative hearing regarding patterns of civil rights violations by law enforcement officers. My personal experience with these officers provides first-hand evidence relevant to the pattern we're examining. She opens the thick folder before her, the one compiled over the weekend from federal investigations that have been ongoing for months. This hearing concerns not just the events of Thursday, October 10th, but a documented pattern of behavior spanning several years. The federal government has been investigating your department for 16 months, gathering evidence of systematic violations of citizens' civil rights under color of law. This is entrapment, Norwood bursts out, forgetting courtroom protocol in her anger. You set us up. Captain Norwood, you will address the court properly or be held in contempt. Amara's voice carries the kind of authority that comes from years of federal service. And for the record, entrapment requires inducing someone to commit a crime they wouldn't otherwise commit. I was parked legally in a public garage. Your officers initiated contact without reasonable suspicion, manufactured false charges, and violated multiple constitutional rights. No one induced you to do anything. You followed your standard operating procedure. She turns to the court reporter. Let the record show that present are Officers Tyler Briggs, Marcus Rend, Sergeant Dana Hutchfield, Detective Roy Vance, and Captain Leslie Norwood, represented by counsel Gerald Foster. Also present is Assistant U.S. Attorney Catherine Walsh, representing the federal government's interests in this matter. Catherine Walsh, 38, former Civil Rights Division prosecutor, stands with a box of evidence that makes a solid thud when she places it on her table. Your Honor, the government is prepared to present evidence of systematic civil rights violations under 18 U.S.C. Section 242 and patterns of misconduct that warrant federal oversight under 42 U.S.C. Section 141. Your Honor, Foster tries again, sweat visible on his forehead despite the courtroom's aggressive air conditioning. My clients haven't been properly informed of the charges against them. This is a violation of due process. Amara pulls out another document, this one bearing the seal of the Department of Justice. Mr. Foster, your clients were served with notice Saturday evening detailing the nature of this administrative hearing. This is not a criminal proceeding, yet. This is an administrative review to determine whether federal oversight of your client's department is warranted and whether individual officers should face decertification, termination, or referral for criminal prosecution. She looks directly at the 5 officers, seeing in their faces the same dismissive arrogance they showed Thursday, now tempered with growing fear. Ms. Walsh, please present the government's evidence. Walsh stands, her preparation meticulous. Your Honor, I'd like to begin with Exhibit A, security footage from City Parking Structure B, October 10th, 2:14 p.m. through 3:47 p.m. The large screen mounted on the courtroom wall comes to life, showing crystal-clear footage of the parking garage. There's Amara's Honda Accord entering the garage, taking ticket, proceeding to space B14. The timestamp shows 2:14:33 p.m. She parks perfectly between the lines, displays her valid monthly pass, and begins organizing papers in her car. As the court can see, Walsh narrates, Judge Winters was legally parked in a public facility with a valid permit visible. Now, let's advance to 2:17:44 p.m. The footage shows Officer Rend approaching the vehicle. No violation visible, no suspicious behavior observed. He circles the car once, speaks into his radio, and within 90 seconds, Briggs arrives. Then Hutchfield, then Vance, then Norwood. 5 units responding to one woman sitting in a legally parked car. Objection, Foster stands. This footage doesn't include audio. We don't know what was said. Sustained as to the lack of audio, Amara rules, knowing what's coming next. Ms. Walsh, do you have audio evidence? Yes, Your Honor. Exhibit B, Officer Briggs's body cam footage, which he believed was disabled, but was actually in audio-only mode due to a malfunction he wasn't aware of. The courtroom fills with Briggs's voice from Thursday. Your kind always parks wherever you want, don't you? The words hang in the air like an accusation turned backwards, evidence of exactly the bias they've always denied. The audio continues, every lie captured, every manufactured charge documented. She's trespassing. Lie. It's a public garage. I smell marijuana. Lie. There was none. She's resisting. Lie. The video shows complete compliance. Briggs shrinks in his chair with each word, his own voice condemning him more thoroughly than any testimony could. Exhibit C, Walsh continues relentlessly, dispatch recordings from the same time period. The speakers crackle with official radio traffic. Unit 23 requesting backup at City Parking Structure B, uncooperative suspect refusing lawful commands. The timestamp is 2:19:03 p.m., before Amara had even been asked to exit her vehicle, before any commands had been given to refuse. This demonstrates coordination, Walsh explains to the record. The officers called for backup before any interaction that would justify it, suggesting predetermined intent to escalate the situation. Foster objects repeatedly, each objection weaker than the last. His clients shift uncomfortably, realizing their coordinated stories are falling apart under the weight of recorded evidence. Exhibit D, Walsh pulls out a thick folder. Complaint histories for all 5 officers showing a clear pattern of racial bias in their stops, arrests, and use of force. The statistics are damning. Officer Briggs, 89% of his arrests over 5 years have been black citizens, in a city that's 31% black. Officer Rend, 14 complaints in 14 months, all for minorities, all dismissed by Internal Affairs. Sergeant Hutchfield, a pattern of escalating minor infractions into arrests, but only for black and Hispanic citizens. Detective Vance, evidence tampering allegations in 7 cases, all involving black defendants. Captain Norwood, discrimination complaints from 16 officers under her command, all minorities, all dismissed or resulting in the complaining officer being transferred. Your Honor, Foster's voice has lost its confident edge. Statistics don't prove intent. No, Amara agrees, but they establish pattern, and when combined with direct evidence of discriminatory behavior, they paint a clear picture. Ms. Walsh, continue. Exhibit E, the booking report filed by Officer Briggs, stating that Judge Winters was arrested for trespassing, resisting arrest, providing false information, and possession of marijuana. Walsh hands copies to Foster and the court clerk. I'd like to draw the court's attention to several discrepancies. First, the trespassing charge claims Judge Winters had no right to be in the garage, yet her parking permit was valid and paid through 4:17 p.m. Second, the resisting arrest charge describes aggressive resistance, yet the video shows complete compliance. Third, the false information charge claims she gave a fake name, yet she provided her actual driver's license. Fourth, the possession charge references marijuana found in the vehicle, yet the impound inventory shows no drugs were recovered. Those are clerical errors, Vance interjects before Foster can stop him. Detective Vance, you'll have your opportunity to explain, Amara says coolly, though I'd remind you that sworn officers filing false reports is a federal crime under 18 U.S.C., Section 1001. The morning continues with relentless precision. Exhibit F, text messages between the officers from Thursday night through Sunday, discussing how to align their stories. Exhibit G, Previous federal consent decrees from other departments showing identical patterns. Exhibit H. Recordings from the jail showing denial of medication and phone calls, violations of the 8th and 6th Amendments, respectively. By noon, the evidence fills 3 tables. The officers' faces show the progression from arrogance through fear to something approaching panic. They're realizing this isn't a typical internal affairs investigation that can be dismissed, not a civil lawsuit that the city will settle quietly. This is federal intervention with the full weight of the Justice Department behind it. Your Honor, Walsh stands for her final presentation. I'd like to call our first witness. The courtroom door opens and U.S. Marshal Raymond Davis enters, the same marshal who observed at the jail Thursday night without intervening. He takes the witness stand with military precision. Marshal Davis, Walsh begins, were you present at the county jail on the night of October 10th? I was. In what capacity? I was directed by the U.S. Attorney's Office to observe the treatment of a federal officer who had been arrested under suspicious circumstances. Foster objects. Your Honor, Judge Winters' federal employment wasn't known to my clients. Sustained as to their knowledge, Amara rules, but the witness may testify to what he observed. Davis continues with clinical detail. I observed the denial of prescribed medication despite medical disclosure. I observed the denial of phone calls despite repeated requests. I observed the placement in solitary confinement without justification. I observed what appeared to be punitive treatment rather than standard processing. And did you intervene? Walsh asks. No. My orders were to observe and document, not to reveal the federal interest in the case. Intervention would have compromised the investigation into systematic patterns of misconduct. The officers exchange glances, realizing they've been under federal surveillance longer than just Thursday. Every violation they thought went unnoticed was actually being documented, building a case they never saw coming. The government rests its initial presentation, Walsh announces, returning to her seat with the confidence of someone who knows the verdict is already decided by the evidence. Mr. Foster, Amara turns to the defense attorney, would your clients like to present their version of events? Foster huddles with the 5 officers, their whispered conference growing heated. Norwood wants to testify, to explain, to justify. Vance wants to claim the 5th. Briggs looks like he might be sick. Hutchfield stares at Amara with undisguised hatred. Wren seems to be calculating whether cooperation might save his career. Your Honor, Foster finally stands, my clients would like to invoke their 5th Amendment rights against self-incrimination. They certainly may do so, Amara responds. But I'd remind them this is an administrative hearing, not a criminal trial. Invoking the 5th Amendment here doesn't prevent administrative consequences, including termination and decertification. It also doesn't prevent the evidence already presented from being forwarded to the criminal division for prosecution. She lets that sink in before continuing. Additionally, Officer Vance should be aware that he's currently under separate federal investigation for evidence tampering in 3 unrelated cases. Detective Vance, you might want to consider whether cooperation here could benefit you in those matters. Vance's face drains of color. He didn't know the federal investigation had progressed that far, didn't know his other activities had been discovered. The house of cards isn't just falling, it's being deliberately demolished, card by card, with federal precision. May I have a moment with my client? Foster asks, pulling Vance aside. While they confer, Amara addresses the remaining officers. I want you to understand what's happening here. This isn't about Thursday's arrest, though that incident provides clear evidence of your pattern of behavior. This is about 16 months of federal investigation into your department's systematic violation of civil rights. Thursday simply provided the final evidence needed to proceed with federal intervention. She pulls out another file, this one marked with DOJ seals. The Department of Justice has already prepared a consent decree that would place your department under federal oversight for a minimum of 3 years. Every arrest, every use of force, every complaint will be reviewed by federal monitors. Your policies will be rewritten, your training will be overhauled, and officers who demonstrate patterns of bias will be terminated. You can't do this, Norwood says, forgetting protocol again. We have union protections, qualified immunity. Qualified immunity protects you from civil lawsuits when you're performing discretionary functions. Amara interrupts, her voice sharp with legal precision. It doesn't protect you from criminal prosecution for violating federal law. It doesn't protect you from administrative termination for pattern misconduct. And it certainly doesn't protect you from federal oversight when your department demonstrates systematic constitutional violations, she continues, each word measured. As for union protections, I'd remind you that federal law supersedes local collective bargaining agreements when civil rights violations are involved. Your union can't protect you from the consequences of violating federal law. Foster returns with Vance, who looks like a man seeing his future disappear. Your Honor, Detective Vance would like to make a statement. Proceed. Vance stands, his hands shaking slightly. Thursday wasn't unusual. We target certain areas, certain people. Captain Norwood calls it proactive policing, but we all know what it really is. We have quotas, unofficial, never written down, but if you don't make enough arrests in certain neighborhoods, you get bad shifts, bad evaluations. Shut up, Norwood hisses, but Thompson steps forward, hand on his service weapon, and she falls silent. Continue, Detective Vance, Amara prompts. The parking garage. We patrol it specifically looking for people who don't belong. And by belong, I mean... He trails off, then forces himself to continue. I mean white. If someone black or Hispanic parks there, especially near the federal building, we find a reason to make contact. Expired tags, tinted windows, suspicious behavior, we can always find something. The confession hangs in the air like a toxic cloud. Foster looks like he wants to object, but knows there's no legal basis to stop his client from incriminating himself and others. Thursday, Vance continues, his voice stronger now, like confession brings its own momentum. Officer Wren called it in before he even approached the car. He saw a black woman in a nice car near the federal building and assumed she didn't belong there. Everything after that was just building a case to justify what we'd already decided to do. And the marijuana? Walsh prompts from her table. There was never any marijuana. Sergeant Hutchfield always claims she smells it when she wants to search a car. It's impossible to disprove, gives us probable cause, and even if we don't find anything, we can claim the suspect must have ditched it. Hutchfield starts to stand, but Foster grabs her arm, forcing her back down. The truth is spilling out now, unstoppable, each confession building on the last. The false information charge, Walsh continues. Standard practice when someone questions our authority. We claim they gave false information initially, even if they didn't. It's our word against theirs, and who's the judge going to believe? The irony of that statement, made to the very judge they falsely arrested, isn't lost on anyone in the courtroom. Detective Vance, Amara leans forward. Are you stating, under oath, that you and your fellow officers routinely manufacture charges against citizens based on their race? Vance looks at his fellow officers, Briggs avoiding eye contact, Wren staring at the floor, Hutchfield radiating fury, Norwood calculating damage control, and makes his choice. Yes, Your Honor. It's department culture, has been for years. The court reporter's fingers fly across her keys, capturing every word for the federal record. This testimony will be read in criminal proceedings, civil rights lawsuits, and DOJ presentations to Congress about the need for police reform. Mr. Foster, Amara turns to the defense attorney. Do your other clients wish to respond to Detective Vance's testimony? Foster looks at his remaining clients like a man surveying a disaster scene. Your Honor, may I request a brief recess to confer with my clients? 15 minutes, Amara grants, knowing that no amount of conference will change what's already been admitted into federal record. As the courtroom clears, she remains on the bench, thinking about the 18 hours she spent in jail, the mockery, the laughter, the casual cruelty of people who thought their badges made them untouchable. They're about to learn otherwise. When court reconvenes, Foster looks defeated. Your Honor, my clients maintain their Fifth Amendment rights, with the exception of Officer Wren, who would like to make a brief statement. Wren stands, younger than the others, perhaps still salvageable if he chooses the right path. Your Honor, I've only been on the force 14 months. I was trained by Officer Briggs, supervised by Sergeant Hutchfield. I was told this was how policing works, that we had to be proactive, that certain people in certain areas were automatically suspicious. He pauses, swallowing hard. Thursday, when I saw you, Judge Winters, in that garage, I called it in because that's what I was trained to do. Officer Briggs always said, better to make contact and find nothing than let something slide and have it come back on you. I didn't question it. I should have, but I didn't. It's not an excuse, but it's an explanation. The systematic nature of the bias, passed down from senior officers to rookies, creating a culture where constitutional violations become standard operating procedure. Officer Wren, Amara asks, were you ever instructed on constitutional requirements for reasonable suspicion? In the academy, yes, but on the street, Officer Briggs said academy training was theoretical and real policing was different. And you believed him? He's been on the force 12 years. He had commendations, good reviews from Captain Norwood. Why wouldn't I believe him? The question hangs in the air. Why wouldn't a rookie believe a decorated veteran, especially when the entire command structure reinforces the same behavior? Ms. Walsh, Amara turns to the prosecutor. Does the government have any additional evidence to present? Yes, Your Honor. I'd like to submit Exhibit I, a compilation of social media posts by the defendants from Thursday night through Sunday morning. The screen fills with Facebook posts, tweets, Instagram stories. Briggs posting, "Another drug dealer off the streets." Thin blue line. Hutchfield sharing a meme about criminals crying racism when they get caught. Norwood writing a lengthy post about how certain people always claim discrimination when they face consequences for their actions. Each post timestamp shows they were made after Amara's arrest while she was in custody, while they thought they'd successfully criminalized another black citizen who dared to exist in a space they controlled. These posts, Walsh explains, demonstrate not just bias but celebration of what they believed was successful targeting of a black citizen. They show consciousness of guilt. They knew what they were doing was wrong, but believed they'd gotten away with it. Foster doesn't even object. There's no defense for officers publicly celebrating the false arrest of a federal judge, even if they didn't know her identity at the time. Your Honor, Walsh continues, the government requests that this court make formal findings of systematic civil rights violations and recommend immediate federal oversight of the department, termination of the 5 officers present, and referral to the Criminal Division for prosecution under 18 U.S.C. Section 242. If you're still watching, share this story, because every share helps expose the truth about systematic injustice that too many face every single day. Amara nods, having already made her decision based on the overwhelming evidence. Mr. Foster, any final arguments? Foster stands, straightening his tie in a gesture that seems more habit than hope. Your Honor, my clients are human beings who made mistakes. They're products of a system that trained them, supervised them, and rewarded them for the very behavior now being condemned. While I don't excuse their actions, I ask the court to consider that changing systematic problems requires more than just punishing individuals. It's not a bad argument, the Nuremberg defense dressed in modern clothing, but it fails for the same reason it always fails. Mr. Foster, Amara responds, your clients took oaths to uphold the Constitution. That oath doesn't include an exception for department culture or supervisor encouragement. Each of them made individual choices to violate citizens' rights, to file false reports, to participate in systematic bias. The fact that the system enabled them doesn't absolve them of personal responsibility. She turns to address the officers directly. You had power, and you abused it. You had trust, and you betrayed it. You had the opportunity to protect and serve all citizens equally, and you chose instead to become predators, targeting those you deemed unworthy of constitutional protection. Her voice carries the weight of personal experience now. Thursday, you arrested me for parking while black. You manufactured charges, violated my rights, and laughed while doing it. You put me in a cage for 18 hours because you could, because you thought your badges made you untouchable, because you believed the system would protect you as it always has. She pauses, letting the moment build. You were wrong. Standing, she reads from her prepared judgment. This court finds that Officers Tyler Briggs, Marcus Rend, Sergeant Dana Hutchfield, Detective Roy Vance, and Captain Leslie Norwood have engaged in a pattern of systematic civil rights violations under color of law. This court further finds that these violations are part of a broader pattern within their department requiring immediate federal intervention. The formal language continues, each finding another nail in their professional coffins. This court recommends immediate termination of all 5 officers, permanent revocation of their law enforcement certifications, and referral to the United States Attorney for Criminal Prosecution under 18 U.S.C. Section 242, conspiracy to violate civil rights. Furthermore, this court recommends that the Department of Justice immediately implement a consent decree placing the entire department under federal oversight for a minimum of 5 years, with mandatory retraining on constitutional rights, new use of force policies, and quarterly reviews of all arrests and complaints. She looks at each officer one last time. You thought Thursday was just another arrest, another black citizen you could process through your system without consequence. Instead, it became the evidence that exposed your entire pattern of misconduct. Every laugh, every lie, every violation has been documented and will follow you for the rest of your lives. The gavel falls with finality. This court is adjourned. The aftermath is immediate. Norwood storms out, already on her phone, probably calling the union president or her political connections, not yet understanding that federal intervention supersedes local politics. Hutchfield follows, muttering threats about lawsuits and appeals that will go nowhere. Briggs sits stunned, his 12-year career evaporating in a single morning. Rend approaches the bench, perhaps to apologize, but Thompson steps between them, maintaining protocol even now. Vance remains seated, knowing his cooperation might reduce his criminal sentence but won't save his career. Foster gathers his papers with the resignation of someone who knew this outcome was inevitable from the moment Amara entered in judge's robes. He'll file appeals, go through the motions, bill hours to the police union, But the federal case is airtight, built on their own words, their own actions, their own recordings. Catherine Walsh approaches the bench after the others have left. "Judge Winters, the criminal division will want your testimony when charges are filed." "I'll cooperate fully," Amara assures her. "Though I've already submitted a detailed affidavit covering Thursday's events. The officers don't realize it yet," Walsh observes, "but Detective Vance's testimony opens them up to hundreds of civil suits from everyone they've falsely arrested over the years. The city's insurance won't cover deliberate constitutional violations. They'll lose everything: pensions, homes, savings." It's true. The civil consequences will follow the criminal ones, a cascade of accountability they never saw coming when they decided to target a black woman in a parking garage. As the courtroom empties, Amara removes her robes in the preparation room, hanging them carefully for the next time justice needs serving. The federal seal on the pocket catches the light one last time, a reminder that justice, while sometimes delayed, eventually arrives. Outside the courthouse, media vans are already gathering. Someone, probably Vance's lawyer hoping for leniency, has leaked the story. By evening, it will be national news. Federal judge arrested on false charges presides over officer's hearing. The headline writers will have a field day, but the real story is more complex than any headline can capture. It's about systematic racism dressed in uniform. It's about the casual cruelty of those who believe their badges grant them superiority over the citizens they're supposed to serve. It's about the thousands of victims who didn't have federal authority to fight back, who took plea deals because fighting was too expensive, who have records now because officers needed to make quotas. Her phone buzzes with texts from colleagues, from civil rights organizations, from reporters seeking comments. She ignores them all for now. There's still work to do: a formal report to file with the DOJ, criminal testimony to prepare, and her regular caseload that was postponed for this hearing. But first, she drives to the parking garage where this all started. Space B14 is empty this Monday afternoon. She parks in it again, legally as always, and sits for a moment remembering Thursday. The fear she had to suppress, the dignity she had to maintain, the 18 hours of deliberate degradation designed to break spirits and force compliance. A security guard approaches, different from Thursday, an older black man with kind eyes. "Everything okay, ma'am?" "Yes," she tells him. "Everything's finally okay." He nods and continues his rounds, not knowing he's just checked on a federal judge, not knowing this parking space has become evidence in a federal case, not knowing that everything changed here 4 days ago. Her phone rings. It's the U.S. Attorney himself. "Judge Winters, I wanted to personally thank you for your service. What you endured Thursday, what you accomplished today, it's going to make a real difference." "Will it?" she asks, genuine uncertainty creeping through. "Or will they just be replaced by 5 new officers trained in the same system?" "The consent decree will change the system," he assures her. "Federal oversight, mandatory retraining, new policies, new leadership. It won't be perfect, and it won't be immediate, but it will be different." Different. Not fixed, not solved, not perfect, but different. Sometimes that's all justice can accomplish. Incremental change, precedent by precedent, case by case, until the arc of history bends a little more toward justice. She ends the call and starts her car, leaving the parking garage for what might be the last time. She has no reason to return here, no cases in the state court, no business that requires parking in this particular structure. But she knows she'll come back occasionally, park in B14, and remember that sometimes justice requires sacrifice, sometimes change requires evidence, and sometimes the system can only be fixed by those willing to experience its failures firsthand. The drive home takes her through neighborhoods where similar injustices happen daily. Traffic stops that escalate without reason, searches based on skin color rather than suspicion, arrests that destroy lives over violations that would earn warnings in wider neighborhoods. Today's victory helps, but it's one department in one city in a nation full of similar problems. At a red light, she sees a police car in her rearview mirror. For a moment, the old fear returns. Will they pull her over in retaliation? Will there be consequences for holding their colleagues accountable? But the light turns green, she proceeds, and the police car turns left, just another moment in traffic rather than another confrontation. At home, she finds packages on her doorstep. Flowers from civil rights organizations, a thank you card from a mother whose son was falsely arrested by Officer Briggs last year, a handwritten note from an anonymous officer in the department saying, "Thank you for doing what we couldn't do from the inside." The evening news leads with the story. Security footage from the parking garage plays on screen while commentators debate police reform, qualified immunity, and systemic racism. Captain Norwood appears briefly, claiming she's been scapegoated, that one incident shouldn't define entire careers. The reporter notes that the one incident was actually part of a 16-month federal investigation into hundreds of incidents. Detective Vance's lawyer appears next, spinning his client's cooperation as heroic whistleblowing rather than desperate self-preservation. Officer Briggs's wife posts on social media that her husband is a good man who made mistakes. The police union president calls for appeals, investigations into the setup, and solidarity with the falsely accused officers. But the federal documentation stands. The video evidence is uneditable. The testimony is under oath. The pattern is undeniable. And somewhere in federal prison, 5 officers will eventually serve time for crimes they committed while wearing badges they dishonored. Tuesday morning brings the inevitable backlash. Death threats on her voicemail, angry emails calling her everything from race baiter to worse slurs. The U.S. Marshals increased security at her home and office, a reminder that holding law enforcement accountable comes with its own dangers. But there's also support. The NRAACP offers legal assistance for any civil suits. The ACLU requests her participation in a national symposium on police reform. Other federal judges reach out, sharing similar experiences they never reported, thanking her for the courage to document what they only endured in silence. Wednesday, the criminal charges are filed. Officers Briggs, Rend, Hutchfield, Vance, and Norwood are arrested by federal agents at their homes in coordinated early morning raids. The irony isn't lost on anyone. They who conducted so many unnecessary raids are now experiencing the knock at dawn, the handcuffs, the perp walk they subjected others to so casually. The booking photos show their faces without the confidence badges provided. Briggs looks older, defeated. Hutchfield's expression is pure rage. Norwood maintains the indignation of someone who still doesn't believe consequences apply to her. Wren seems relieved, like accountability is almost preferable to the guilt. Vance stares straight ahead, already calculating plea deals and reduced sentences. Their bail hearings are held in federal court, a different judge, as Amara has recused herself from all criminal proceedings. But she watches from the gallery as they stand where she stood 5 days ago, experiencing the system from the other side, feeling the weight of charges that aren't manufactured, facing evidence that isn't planted. The judge sets bail at $50,000 each, high enough to hurt but low enough that they'll likely make it. The conditions include surrender of firearms, no contact with witnesses, and GPS monitoring, standard for defendants accused of violating civil rights under color of law. As they're let out, Briggs makes eye contact with Amara. For a moment, she sees not the arrogant officer from Thursday, but a broken man beginning to understand the magnitude of what he's lost. His pension, his reputation, his freedom, all sacrificed for the momentary satisfaction of targeting someone he deemed lesser. Thursday marks 1 week since the arrest. Amara returns to her regular docket, hearing cases about employment discrimination, social security appeals, regulatory violations, the mundane machinery of administrative law that keeps society functional. But everything feels different now, charged with the awareness of how easily rights can be violated, how quickly freedom can be lost, how systematically justice can be denied. During lunch recess, she checks the news. The consent decree has been signed. Federal monitors are already reviewing department policies. 3 more officers have been suspended pending investigation into similar patterns of bias. The police chief has announced his retirement, claiming it's unrelated to the federal intervention nobody believes. Her phone buzzes with a text from Marcus Chen, the public defender who visited her in jail. "Thought you should know. Diamond and the cat lady from your holding cell had their charges dropped. Prosecutor said the arresting officer's credibility is shot." It's a small victory, but meaningful. 2 women who would have plea bargained to crimes they didn't commit are free because 5 officers' patterns of misconduct finally had consequences. Friday afternoon, she receives an unexpected visitor. Former officer, Marcus Rend, stands in her chamber's doorway, his lawyer beside him. "Judge Winters, my client would like to apologize," the lawyer says formally. Rend steps forward, younger without his uniform, vulnerable without his badge. "I know apologies don't undo what happened, but I want you to know I'm testifying fully in the criminal cases. I'm cooperating with the federal investigation, and I'm working with the DOJ to identify other officers engaged in similar patterns." "Why?" Amara asks simply. "Because Thursday, when I realized who you were, what we'd done, I couldn't pretend anymore that we were the good guys. We were the criminals, just with badges. It's not redemption, not yet, maybe never. But it's recognition, and sometimes that's where change begins, with someone acknowledging the truth everyone else already knows. Your cooperation will be noted in your sentencing," she tells him, formal rather than forgiving. "But understand that accountability isn't just about criminal consequences. It's about the lives you've damaged, the trust you've broken, the community you've harmed. He nods, understanding that his 2 to 5 years in federal prison is just the beginning of a lifetime of consequence for 14 months of constitutional violations. After they leave, Amara sits in her chambers thinking about cycles, how bias becomes policy, how policy becomes practice, how practice becomes culture, how culture becomes so entrenched that it takes federal intervention to break it. But also how one incident, documented thoroughly, can begin the breakdown of those cycles. Her desk phone rings. It's the chief judge of the district. Amara, I wanted you to know that what you did, not just the hearing, but putting yourself through that arrest, it's already having ripple effects. 3 other cities have requested DOJ investigations based on similar patterns. Your case is being cited as precedent for federal intervention in systematic civil rights violations. Precedent. In law, it's how change happens, one case establishing principles that apply to thousands of others. Her 18 hours in jail becoming the foundation for protecting countless others from similar injustice. The weekend passes quietly. The death threats have been traced and arrests made. Ironically, some from officers in other departments who saw the federal intervention as an attack on all law enforcement. The marshals maintain their protective detail, but the immediate danger seems to have passed. Monday morning, 2 weeks after the arrest, she returns to the parking garage one last time. Not to park, just to see. The space B14 has a new sign. Reserved, federal officials only. Someone in city management, desperate to avoid another incident, has designated spaces specifically for federal employees. It's missing the point entirely. The problem wasn't where she parked, but how she was treated for existing while black in a space someone decided she didn't belong. But it's also typically bureaucratic, addressing symptoms rather than causes, changing policies rather than culture. As she stands there, another black woman pulls into a nearby space, glances around nervously, checks her parking permit twice, takes a photo of her legally parked car. The trauma of existing under constant suspicion, the exhausting vigilance required to protect yourself from those supposedly protecting you. You're okay, Amara tells her quietly. Park wherever you're legally allowed, document everything, and know your rights. The woman looks at her, perhaps recognizing her from the news, perhaps just grateful for the reassurance. Thank you. It's just, after what happened here, Amara says firmly, is that officers who violated someone's rights faced consequences. That's what should happen everywhere, every time. The woman nods, shoulders straightening slightly, and heads toward her destination with a bit more confidence. It's a small interaction, but it matters. Every person who knows their rights, who documents violations, who refuses to accept injustice as inevitable, changes the calculation for those who would abuse their power. Back in her chambers, Amara finds a letter that must have been hand-delivered over the weekend. No postmark, just her name written in careful script. Inside, a single paragraph. Judge Winters, I'm an officer in the department. I've been on the force 8 years. I've seen everything you documented and worse. I've tried reporting it, but internal affairs always dismisses complaints from inside. Thank you for doing what we couldn't. The consent decree gives us hope that things might actually change. Some of us want to be better. We just need the system to let us. Unsigned, of course, but genuine in a way that suggests not all officers are beyond redemption, that systemic change might find allies in unexpected places. The criminal trials won't start for months. Federal cases move slowly, methodically, building overwhelming evidence rather than rushing to convictions. But the administrative consequences are immediate. The 5 officers have been terminated, their certifications revoked, their names added to the federal Brady list that prevents them from ever testifying as law enforcement witnesses again. The city has already settled Amara's civil suit for an undisclosed amount that she's donating entirely to a legal fund for others falsely arrested by the same officers. The money won't undo their trauma, but it might help clear their records, restore their reputations, rebuild their lives. 3 months later, at the federal criminal trial, Amara takes the stand. She testifies for 4 hours, methodically detailing every moment from Thursday afternoon through Friday morning. The defense attorneys try to shake her, to find inconsistencies, to suggest she orchestrated everything. But the evidence speaks louder than their desperate theories. The jury, 7 white, 3 black, 2 Hispanic, deliberates for just 6 hours. Guilty on all counts for all 5 defendants: deprivation of rights under color of law, conspiracy to violate civil rights, filing false reports, obstruction of justice. Sentencing comes 2 months later. Briggs gets 4 years, Hutchfield gets 5. Norwood, as the supervisor who enabled it all, gets 7. Vance, with his cooperation and testimony, gets 2. Rend, the youngest with the shortest record of violations, gets 18 months and probation. As they're led away in federal custody, Amara feels no satisfaction, no victory, just a sense of completion. Justice has been served, but it can't undo the thousands of false arrests, the destroyed lives, the community trust shattered by those who wore badges while breaking laws. A year later, the first federal monitoring report is released. Arrests are down 30%, but legitimate crime reporting is up 15%, suggesting people are more willing to call police when they trust they won't become victims themselves. Use of force incidents have dropped 45%. Complaints are being investigated by federal monitors rather than internal affairs, and 12% are being sustained compared to the previous 0.3%. It's progress, slow and incomplete, but measurable. The culture is changing, officer by officer, policy by policy, day by day. Some officers have quit rather than adapt. Others have embraced the changes, finding they can actually protect and serve better when they are not warriors in an imaginary war. Amara continues her work as a federal administrative law judge, but now she's also called to testify before Congress about police reform, to train other judges on recognizing civil rights violations, to speak at law schools about the intersection of personal experience and professional obligation. Every time, she starts with the same words. On Thursday, October 10th, I parked legally in a public garage. And every time, she ends with the same message. Justice isn't about revenge or punishment. It's about accountability and change. It's about ensuring that the rights we claim to cherish are actually protected for everyone, not just those deemed worthy by those in power. The parking garage incident has become a case study in law schools, a training example for police academies, a rallying cry for reform advocates. But for Amara, it remains something more personal. 18 hours of injustice that revealed decades of systematic violations, a sacrifice that exposed a truth everyone knew but couldn't prove. 5 years later, when the consent decree is finally lifted, the department is fundamentally different. New leadership, new training, new policies, new culture. Not perfect, no human institution ever is, but better. Accountable, constitutional. Officer Rend, released after serving 14 months, now works with a nonprofit training police departments on implicit bias and constitutional requirements. He'll never wear a badge again, but he's found a different way to serve, to atone, to prevent others from making his mistakes. The others have scattered to the winds. Briggs works construction in another state, his law enforcement career a cautionary tale. Hutchfield fled to a state that still lets her carry a gun, posting bitter messages about the war on police that got her convicted. Vance disappeared entirely after his release, perhaps understanding that invisibility is preferable to infamy. Norwood still maintains her innocence, filing appeals that go nowhere, writing letters to newspapers that don't get published, claiming victimhood while her actual victims rebuild their lives. And Judge Amara Winters continues to serve, continues to document, continues to hold power accountable to law. Because that Thursday in October taught everyone, that justice delayed doesn't always mean justice denied. Sometimes it just means justice documented, waiting for the right moment, the right evidence, the right courage to transform violation into vindication. The parking garage's space B14 no longer bears any special designation. It's just another parking space in a public garage where anyone can park legally without fear of arrest for existing while black. That's not a complete victory, but it's a beginning. And in the long arc of justice, beginnings matter. Every Thursday at 2:17 p.m., the exact time Officer Rend first approached her car, Amara takes a moment of silence. Not for herself, but for all those still facing similar injustice without federal badges to protect them, without resources to fight back, without the privilege of turning their trauma into transformation. The work continues. The system still needs fixing. Officers still violate rights. Citizens still suffer injustice. But now there's precedent. Now there's proof. Now there's a federal case that says parking while black isn't a crime, and those who treat it as one will face consequences. It's not enough. It's never enough. But it's something. And sometimes, in the slow grind toward justice, something is everything.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.